there is still the common sense practical explanation that he didn't want to he didn't want to run the risk of prosecution. So he withheld it, not necessarily because it would have been bad for him in these proceedings, but because he knew his dad was being investigated and he just wanted to stay out of trouble. If that's his motivation, what justifies drawing the inference that the evidence would have been unfavorable to him for the purposes of the match-fixing disciplinary proceeding?
To answer that question, Professor Liu, we have to understand what the appellant is claiming, and they're claiming that handing over the phone will be a circumvention of his privilege against self-incrimination. And the very nature of their claim means that there's possibly something incriminating on his phone, and therefore is invoking this privilege to protect himself. And by preventing the FIFA from obtaining his phone and rejecting their request to cooperate, there's clearly something on his phone that would be incriminating. If not, why would the appellant even claim that Article 6 would be applicable to them?
But my point is, it could be incriminating in many senses, right? It could be incriminating simply in the sense that it might get him tied more closely to whatever his father was doing, which had got his father investigated. It might not be something that actually pertains to the particular suspected wrongdoing here.
I note that my time has elapsed. If I may quickly answer your question.
Just answer in a sentence.
Well, the nature of the fact-finding process is to ascertain the entire circumstance that's been provided to them. And in the phone, as rightfully pointed out by Professor Liu, there could be evidence that goes in favor or against the appellant's claims. But that is the nature of the fact-finding process itself. And by preventing such a process from even occurring, we will argue that the doctrine of adverse inference will be applicable in our case with respect to the last issue. Okay. I'll now hand over my time to my co-counsel, Mr. Ramesh Kanna, who will address the remaining two issues on appeal. Thank you.
Good morning, Professor Liu. My name is Ramesh Kanna and I act for the respondent, FIFA. Now, in alignment with my co-counsel submissions, the CAS jurisprudence seeks to achieve a balance between both procedural and substantive fairness. Now, opposing counsel submissions invite the panel to treat procedural safeguards as rigid barriers. However, the CAS recognizes that corruption is by nature concealed and leaves no traces. Thus, in cases such as these that confront us today, precedent decisions evaluate fairness in the light of the context rather than through absolute exclusionary rules. Under this understanding, I make two submissions. Firstly, anonymous witness statement and the anonymous email are admissible. And my second submission is that Article 20 of the FIFA Disciplinary Code has indeed been breached by the appellant. Now, with regard to my first submission, I make it on three grounds. Firstly, there was good reason for anonymity. Secondly, the anonymous evidence is not solely relied upon. And thirdly, there are counterbalancing factors safeguarding fair assessment of reliability. Now, before I move on, I note that Professor Liu had asked opposing counsel, what is the legal approach? This goes to the heart of the contention between the appellant submissions and the respondent submissions, because we disagree with the law as stated by the opposing counsel. Opposing counsel refers to the 2019 CAS decision of Karim Keramuddin and just refers to the procedural safeguards undertaken in that case and uses that as rigid exclusionary rules to say that given the fact that the present case does not align, we should not allow anonymous evidence. However, the procedural safeguards that were used in Karim Keramuddin were used so that the three elements that I had stated could be fulfilled. These three elements originate from Article 6 of the ECHR, and given the fact that this tribunal is seated in Switzerland, it is applicable. Now, with regard to the first element of whether there is a good reason for anonymity, in Keramuddin, the very case that opposing counsel refers to, it was stated there is no need to prove an actual threat. A real risk is enough. In that particular case, yes, a co-witness was indeed able to achieve asylum. And opposing counsel seeks to distinguish that from the present case. However, the principle behind this factor was that there was third-party objective evidence of a real risk.
So here's the problem I have with your case. Here we just have people saying they are rumors. There's an anonymous email, there's an anonymous witness statement. Neither of them actually says, oh, I know that Mr. Luke Fortuner is involved with criminal organizations. Both just say he has a reputation. One says he has a reputation, the other says they are rumors. How can that be enough to show a real risk?
I understand the concern, Professor Liu. So beyond these rumors, there's also objective third-hand evidence that shows that there's a real risk. This is proven by the fact that the public prosecutor has released a press release in Exhibit 5 that shows that Mr. Luke Fortuner is indeed undergoing criminal proceedings. It's at page 36 of the paginated record. Now this is analogous to the case of Karim Karamuddin, because in that case, the third-party objective evidence was that a co-witness was able to get asylum. Now, similar to that...
Sorry, let me pause you a moment. Before we move on, what is the significance of the fact that there's an investigation? Because it could just be that the public prosecutor was operating on exactly these same anonymous sorts of tip-offs. What can we conclude from the fact that someone is being investigated?
The threshold to be achieved under this element is not that there is an actual threat, but that there is a real risk of a threat. So it's not a question of...
No, I understand, but the point is, you say that the fact that he's being investigated helps you to cross that threshold of real risk. But that depends on the significance of being investigated, right? Because if people are just... So imagine a legal system which says, well, whenever we receive a report, we will investigate. We will commence investigation. Of course, that would probably be not very practical. But if that were the case, then it wouldn't really say anything about someone that they're being investigated. All it would tell us is that someone has alleged something about them. So could you address us on the significance of the fact that the prosecutor initiated an investigation into Mr. Luke Fortuner?
Well, the first argument that the respondent would put forth is that the fact that a criminal proceeding is going against the appellant's father shows that the public prosecutor of that nation has enough evidence to determine that there is a real possibility that this individual could be a criminal, and therefore they construe criminal proceedings against him. And the second layer to this argument is that...
Is there some legal authority for this?
It would be the exact case that opposing counsel cites, because opposing counsel cites Karamuddin, and in that case they referred to parallel proceedings which gave a co-witness asylum. So it could still be argued that the threshold in that particular...
Parallel proceedings being court proceedings?
Yes.
So there's a bit of a difference there, right? Because the fact that someone was offered asylum means that a court has found that this person faces some risk. But an investigation could just be someone's opinion that we ought to look into it.
We do concede that if we have a direct comparison, the threshold here might be lower. However, then I would fall back on the second layer of this argument, which is that this is just one factor which Karamuddin considered. Karamuddin also considered two other factors, which is power asymmetry and the overarching criminal context of that particular case. Now, in that case, it could not be proven that indeed criminal acts had happened. However, the fact that the allegations were criminal in nature and the fact that the accused had a power asymmetry with the witnesses who were in a vulnerable position also gave further reason for anonymity. And this is...
Right, but here I'm not sure the power imbalance point helps you, because the anonymous witness statement was taken by FIFA, right? FIFA is an immensely wealthy and powerful organization. Could FIFA not have arranged for anonymity from the public and the appellant, but some means of the tribunal or the court confirming the witness's identity? Because it wasn't a Dave and Goliath situation. In fact, if anything, it's the appellant who is disadvantaged. The appellant and his father would be disadvantaged compared to FIFA, right?
The point on power asymmetry is a comparison between the witness and the individual from which reprisal is feared of. So the comparison here would be between the witness that alleges the particular witness statement and Mr. Luke Fortuna's father. So the appellant's father is a wealthy businessman, and that is why we say that there is power asymmetry. With regard to Professor Liu's question on why FIFA could not arrange measures for identification by the panel, it is because it is not necessary, and this would bring me to my third element. I move from the second element because indeed the anonymous evidence and the anonymous witness statement and the anonymous email are not solely relied upon. So with regard to the third element on whether there are counterbalancing factors for safeguarding fairness, what is required is not audio-visual scrutiny or means of figuring out other forms of questioning. Rather, internal and external consistency is enough. External consistency is achieved if the anonymous evidence is corroborated by objective independent evidence. And internal consistency is achieved if the evidence does not exaggerate and limits its claims to its confines. Now, in the present case, neither the witness statement nor the email speculates about betting or criminal arrangements, but confines the act to which what was observed. Now, the witness statement just states that there was a stressed phone call the night before the match, and the email does not claim that the crypto transfers were for match fixing, or that...
That's fair enough, but then I have a couple of questions that arise from that. One links back to a question I asked counsel for the appellant, which is, well, how probative is this really? As you point out, all it says is there was an argument with his father saying, stop pressuring me, I can't go along with everything. That's it. So I worry that this could be a situation where the evidence is not very probative, but could be fairly prejudicial.
I understand the concern, Professor Liu. So with regard to the probative value of the evidence, we do concede that given the fact that there is no metadata confirmation of authenticity, it could be the case that this piece of evidence is not...
The confirmation of authenticity, all that doesn't really go to our probative value. My point is, probative value is if I take it as true, how much does it affect my confidence that a certain relevant fact is or is not established? And my point is that if all this says is that he had an argument with his dad, I'm not sure how much that helps to prove that he was involved in match fixing. So I'm worried that the probative value of this evidence may not be very high. But the prejudicial effect may be significant because it's sort of insinuating bad things, even though we can't actually draw a strict inferential link there.
As far as CAS jurisprudence goes, also I understand that my time has elapsed. So if I could request to answer this question and a further 1 minute to sum up my submissions regarding the second issue.
Yes, just answer the question first and we'll see if we have time for the second submission.
Okay, understand. As far as CAS jurisprudence goes, when we deal with issues of admissibility, the CAS panel does not seek to compare probative value with prejudicial effect of every single piece of evidence. And this is tied to the fact that when there is an inference of guilt, it is not through one sole piece of evidence, but rather through a mosaic of evidences to see if converging strands of evidence can comfortably satisfy the panel on the fact that there is an inference of guilt to be made. And what's to be noted here is...
Fair enough, but just one last question on the evidential point, and then I'll give you a chance to say a little bit about Article 20. Why is there no corroboration? Because it said that he was on the phone with his father, he shouted, and then he stormed out. That implies that this conversation is happening indoors, and the rest of the team seemed to be in the area. Someone else would surely have heard this. So if your client is going to adduce anonymous witness statements to try to prove that this happened, there should be more than one account. And if there were 2 or 3 or 4 anonymous persons say, yeah, we all heard this, it would be much safer to rely on that compared to just one person.
I understand, Professor Liu. So corroboration need not just arise from other witness statements. While I do acknowledge that if there were more anonymous witnesses, this would be of greater value, the reality of the situation is, given the fact that the appellant's father is of significant influence, it could just be a deterrence due to the fear of reprisal.
So no one else dared to speak.
Exactly.
Okay,
However...
Possible. All right, that's good enough for me on that point for now. What's your brief case on the Article 20 substantive issue?
With regard to issue D, in essence, opposing counsel's arguments centered around why each individual piece of evidence does not prove guilt. However, the legal approach required in cases such as this is not whether each individual piece of evidence can prove guilt, but rather if all the evidence taken in totality can comfortably satisfy the panel of guilt. And it is worth noting that this standard of comfortable satisfaction is one that is below the criminal standard of beyond a reasonable doubt. And the significance of this is that regardless of how many alternative theories that the opposing counsel can bring up, even if they do raise a reasonable doubt, this is insufficient to not
Okay, but do you still need to show that it's more likely than not at least?
yes, it's above the civil standard of
Yeah, so I'd just like you to address one key factual contention that counsel for the appellant made, which is if you just look at how their client played, it's not that suspicious for a not particularly good player playing a role that is not his main role.
We indeed agree, Professor Liu. Taken in isolation, the performance by the appellant is not something that is noteworthy. We are cognizant of the fact that these mistakes are quite commonplace, in fact, in most matches. However, what makes it anomalous is the fact that it is corroborated by multiple other objective strands of evidence. Firstly, right before the first goal was conceded at the 23rd minute, at the 20th minute, bookmakers decided to suspend the markets. Now, this is objective in that bookmakers suspend markets when they believe that the game is influenced by non-genuine factors. Now, beyond this, there was also anomalous betting movements. Despite the fact that before the first goal was conceded, the appellant's team actually had 67% possession and were in the lead, the betting reports show that the significant majority betted against the appellant's team. Now, this betting anomaly is another piece of evidence that also goes towards proving an inference of guilt. Moreover,
Okay, I think we don't have that much time. I just want to ask you one question on this point. When you say 67% betting against the appellant's team, is that the percentage over all bets that have been placed at that time, or bets that have been placed recently within that time?
apologies, Professor Liu. Let me re-clarify. The 67% is a statistic that refers to which team had more possession of the ball.
I understand. I didn't mean to say that. I meant, but you said more people were betting against the team.
Yes.
Right, and you had a percentage, or you didn't have a percentage?
There was no percentage.
Okay, but my question is, ignore 67%. I transpose the figures. What I mean is, when you say more were betting against the team, are you saying within this period, new bets coming in were mostly against the team? Or are you saying out of all the bets that in total had been placed at that time, more were against the appellant's team?
All the bets that had been placed prior to the 20th minute, prior to the markets being suspended.
Then that might not tell us very much, because it could be that even before the match began, a lot of people were disfavoring the appellant's team. And maybe watching the play, more people could have started betting in favor of the appellant's team. But overall, there were still more bets against than for, right? So if that statistic is total bets up to that moment, it doesn't necessarily tell us very much, does it?
Understand, Professor Liu. That alternative argument would stand if it were not for the case that the Iridonian team was actually having a successful career prior to this match. As in the previous matches, they had a strong lead with other teams as well. So there was no reason for the mass populace to heavily bet against Iridonia, especially.
What was the initial over and under, or if they don't use those terms, whatever terms they use in this betting market?
If I could refer you to page 13 of the paginated record. You can find it at the match result, under the heading match result, Asian handicap, Iridonia opposed. So in fact, even they had such a lead that even if Iridonia had not considered 3 goals but conceded 2 goals, they would have still advanced forward. That was the significant lead that they had. Yet they lost all 3 goals and ended up not being able to even move forward in the game.
So they were initially the favourites, and then
Yes.
there was this weird movement of betting against them before things even started going.
Yes.
Okay, got it. Is there a rebuttal?
Yes, the respondent has submitted that the Iridonian team was successful before the match. And we argue that, yes, however, there are reasons as to why there was irregularities in the performance. First, the appellant was sick prior to the game. He met with his doctor the day before the game. This is Exhibit 6 at paragraph 10. And even though he was sick, he still chose to play for his country.
No, but you see, I don't think that's the point that counsel for the respondent was making. Counsel for the respondent was saying the team seemed to be in great shape. They were favoured to win. They were actually doing better, at least by the metric of possession, before the first goal was conceded. Yet, betting had already started to move heavily against them, which suggests that something funny was in it. It's almost like people knew something was going to go wrong. I think that's the case. I think it's part of the circumstantial evidence in favour of match fixing.
Yes, and the betting anomaly does not prove guilt. It has been said that, or rather established that, spectators at the stadium has a 3 to 5 second advantage over the broadcasting systems, and therefore this will prove any sort of betting anomalies. And moreover, the Genius report is of opinion and looks at the whole match as a whole, but does not specifically pinpoint one player. And as well, in page 2, paragraph 2, the starting goalkeeper was injured and the appellant was asked to replace the goalkeeper. And therefore, any performance-related issues could be attributed to the fact that he was a new starting goalkeeper for the team.
So why did he have to replace the original goalkeeper?
At page 2, paragraph 2 of the record, the original starting goalkeeper was out due to an injury.
I see. Is there any more information available on the circumstances of the goalkeeper's injury?
Prof, there's nothing else regarding the injury of the goalkeeper. And lastly, we would submit that he was
Sorry, and last thing, when was it known that he had to replace the goalkeeper?
It does not specifically say on the facts. However, page 2, paragraph 2, line 3, it was to replace the team's captain and regular starting goalkeeper due to injury.
Okay, thank you.
Thank you.
Professor Liu, opposing counsel cited a 5-second delay in the broadcast as an explanation. However, the betting statistics that we are referring to span across a period of 20 minutes, which is far greater than a 5-second delay, thus it does not explain. Moreover, he claims that the Genius report is opinionated. However, we are not solely relying on it. I once again reiterate the fact that to form an inference of guilt, there needs to be a convergence of multiple indicators, which is what we see in the present case. And thirdly, the argument that the goalkeeper was incompetent because he was replacing the usual goalkeeper does not stand, when we note that at the time 82-43, there were instances in which the appellant was actually able to block the goal, as Professor Liu had noted earlier as well. I conclude my Sir rebuttals.
Okay, thanks everyone. Shall we go straight to feedback?
Would you like a short break first before?